The second speaker in this panel, Dr. Raphaele Xenidis. She holds a PhD and a Master's of Law in Comparative European and International Laws, as well as a Master's of Political Science. And currently she's employed as a lecturer at Edinburgh Law School. Her research interests are in discrimination and equality law, critical legal theory, human rights law, and the intersection of law and technology. Her postdoctoral research on algorithmic discrimination includes one of the first studies with a focus on AI-driven discrimination under the EU law's approach called Tuning EU Equality Law to Algorithmic Discriminations, and a second study, again written in co-authorship with Linda Senden, about EU non-discrimination law in the era of artificial intelligence.
So good afternoon, everyone, and thank you so much, Professor Yamal, for organizing this conference, and for Michael for moderating this panel. And thank you to Frederic for the brilliant presentation just now. So today, the working title, which was suggested to me and which I accepted with great pleasure, was Non-Discrimination by Design under the Artificial Intelligence Act. And I just took the liberty to add an interrogation mark to this title, and we'll see why. But just before starting, I just wanted to make a small disclaimer that what I'll be presenting to you are some reflections about a work in progress that I'm doing. So it's going to be a very good occasion to reflect on the European Commission's proposal to regulate AI from the more narrow perspective of discrimination and not only from that of fundamental rights. Although, of course, there are a lot of common points between the two perspectives. So in my talk today, I'll first introduce the provisions of the Act that pertain to bias and discrimination. Then I'll flesh out some of the positive contributions that the Act could make to the current framework on non-discrimination law. And finally, I'll expose what I think are some important weaknesses of the proposed act that have been discussed in the literature already, and I'll add some insights from non-discrimination law. So here we go. I'm not going to repeat the concrete examples on AI bias and discrimination that we've heard about just now and this morning as well, but I just want to come back to the notion of non-discrimination by design and why that might be an idea that might be important for us. So here we go. There are important gaps in non-discrimination law. So Professor Borgesius mentioned them already. There are some debates also on whether the conceptual map is fully suited, for example, to intersectional types of discrimination. We have gaps in the material and personal scope. This was also mentioned this morning, with only 6 protected grounds of discrimination in the EU. Although, of course, EU member states are free to go beyond the minimum harmonization approach. We have a redress system which is mostly individual and mostly ex post. So that was also mentioned in the discussion following Félicien and Gaëtan's presentation this morning. And this, of course, might overburden single applicants who first might have a hard time to identify that they have been discriminated against, as we just heard, but also who might have a very hard time bringing evidence to build a prima facie case of discrimination in courts. And then finally, we have this question that Frederic tackled, that the proportionality test, which is linked to the concept of indirect discrimination, would have to be applied by analogy to algorithmic discrimination, which is not an easy task, especially because the optimization choices that are operated by private and public providers or users are difficult to articulate, difficult to assess, because they often happen or often take place between either different fairness strategies or between fairness and accuracy, for example. So very complicated trade-offs, which have to be assessed then by non-expert personnel such as the judiciary. So these are just a few examples of some of the gaps of non-discrimination law, and just to say why a non-discrimination by design approach might be needed. So this has been suggested by some scholars already in the literature, and I'm sure we'll hear more about this in the next presentations, but this idea of a non-discrimination by design strategy would seek to not consider discrimination as a sort of fix to a biased technology, so like a fairness fix, for example, but rather centering or mainstreaming, to use the EU policy lingo, equality throughout the process of creation of these socio-technical systems. And someone was insisting on the word socio-technical system this morning, and I agree with that approach. These are socio-technical systems. So a priori, the AI Act proposal could be regarded as taking such an approach, a non-discrimination by design approach. So now let's turn to the contributions it would make to the protection of the rights to non-discrimination. And I'm going to start by, excuse me, by mentioning a word on the approach that the Act takes. It kind of builds a regulatory puzzle, because the European Commission explains in the memorandum that accompanies the Act that this is going to be in consistency with the Charter of Fundamental Rights and the existing secondary legislation on data protection, consumer protection, non-discrimination, and gender equality. And the Commission insists that the proposal complements existing union law on non-discrimination with specific requirements that aim to minimize the risk of algorithmic discrimination. So what the proposal does, in fact, is to add a specific regulatory layer to existing legal standards while embedding these standards, for example, the current anti-discrimination law framework. And let's look at the Act itself, just very quickly, because we already heard about this, but to refresh your memory, the Act adopts a risk-based approach with 4 categories of risk. Unacceptable risk prohibits, basically, these technologies are prohibited. High-risk systems come with a set of particular requirements and obligations. Limited risk systems can be deployed if they comply with transparency obligations, and a minimal risk category exists as well, where the Commission encourages the uptake of codes of conduct. And I'm going to focus on the high risk category, because it's actually the most interesting for now, although some interesting things can be said also about the other categories. So how is a system classified in a risk category? Well, 2 things. If so the prohibited systems category has a narrow and fixed scope. So for example, it can be manipulative technologies that are harmful, that exploit the vulnerabilities of certain groups of population. And then we have a second thing, which is located in Annex 3 of the Act, and which defines a list of areas where standalone AI systems are automatically considered as high risk. This list of categories is fixed, and it includes, for example, education and vocational training. It includes employment. It includes access to essential private services and public services, etc. So I'm not going to go through the entire list, but this is just to give you first overview of how the AI Act is structured. So I said I would be focusing on the high risk category, where the Act draws up a list of essential requirements, including to keep algorithmic bias in check. So what are these essential requirements? I played a small game, and I copy-pasted the entire Title 3 of the Act into a word cloud generator, and this is what it gives more or less. So we see that words or concepts that appear very important are the idea of risk management, the obligation to provide technical documentations, to keep the logs of the system, the obligation for providers to ensure transparency and interpretability of their system by users, an ex-ante conformity assessment, and the apposition of the CE marking, for example. And we also have 3 articles which are interesting because they explicitly mention the term bias. And these are Article 10 on data and data governance, which mentions basically the necessity to have high quality data, but also to examine biases. Article 14 on human oversight, which should be based, according to this article, on an accurate understanding of the characteristics and limitations of the system and the awareness by the overseer of automation biases. And Article 15 also mentions bias explicitly when it says that feedback loops should be avoided where biased outputs are used as inputs for these systems. So these are just, some of the main specifications or requirements for these systems. And at the core, there is this notion of risk. So risk to safety, risk to health, but also risk to fundamental rights. So let's look at the space that gives to discrimination issues. And here, I examined the semantic choices that the proposal makes. And I found Gaëtan and Felicien's count of the occurrences of the terms bias and discrimination this morning interesting, because indeed the Act gives an impression that discrimination takes on a very important place. So for example, in the explanatory memorandum and in recital 28, we have the idea that it's necessary to consider the extent of the adverse impact caused by the AI system on the fundamental rights protected by the Charter, including non-discrimination and equality between men and women. Then in a series of recitals 35 to 37, we have a warning that AI systems used in core sectors like education, employment, essential services are basically liable to violate the right not to be discriminated against and to perpetuate historical patterns of discrimination. And then a bit further on, recital 44, again, referring to high quality data requirements, there's this idea that one should ensure that the high-risk AI system does not become the source of discrimination prohibited by union law. So this is really the impression that the preamble and the explanatory memorandum give. But, and this is a big but, past the preamble and the explanatory memorandum, the binding part of the proposal does not mention the word discrimination once. So rather it uses the term bias throughout. And I thought it was also interesting to note that the word fairness is entirely absent from the proposal, which is not surprising given the controversies or the polysemy, so to say, of the notion of bias, of the notion of fairness. But the problem is that the notion of bias, and I'm not sure whether it's a problem or an opportunity, but the notion of bias is not defined in the proposal. So we know that it's broader than the term discrimination, but nonetheless, I think it paves the way for potential legal uncertainty concerning the interpretation of the obligations that fall on providers of AI systems. And I'll come back to that point a bit later. So we'll see that these semantic choices have important consequences. And this brings me to the second point of my talk, and that's the positive contribution that the AI Act can make to anti-discrimination law. So there are some qualities, some contributions that the acts can make. And one of them is basically patching up some of the holes of non-discrimination law. And there I'm thinking of its material and personal scope in particular, because the material scope of the EU AI Act is much broader than that of EU anti-discrimination law if you look at Title 3. And so the essential requirements for high-risk systems apply to areas where EU secondary non-discrimination law doesn't have any grip. So for example, in relation to 5 and 4 of the 6 protected grounds, the AI Act can make a contribution, for example, in education and access to essential services, which are not covered there. So some of the preventive measures against AI bias could lead to combating discrimination beyond the areas covered by EU law. In addition to that, the AI Act has this property that it would draw in the Charter, because member states would be implementing EU law when dealing with high-risk systems. So following Article 51 of the Charter, the non-exhaustive list of protected grounds that is located in Article 21 would apply, and therefore it would de facto extend the material and personal scope of EU equality law to public and private actors alike. And there, I think it's important to consider that Article 21 of the Charter has been granted direct horizontal effects by the Court of Justice in cases like Egenberger or IR. The problem here is that the justification test that applies to discrimination under the Charter is an open-ended one, and it has a looser grip than the proportionality test, which is located in secondary law, because Article 52(1) of the Charter basically explains that there are a number of limited circumstances in which you can derogate to the prohibition to discriminate, and these are, for example, certain public interests. And I'll come back to that later, but right now I just wanted to say that bias levels will be therefore subjected to different looser proportionality requirements when applying the Charter. And this, of course, is only in a subsidiary manner, because where EU secondary law applies, the Charter would not apply, or it would apply in an informative manner, so to say. But cases like Glatzel, for example, have indicated how the Charter applies beyond secondary law in such a subsidiary way, so to say. And I'm happy to come back to this after the talk if you're interested. The second contribution I think that the AI Act can make is that it would create a sort of turn to a preventive approach. And that idea of prevention is currently missing in EU secondary anti-discrimination law. So, for example, Article 10, which Jan Lorin already mentioned this morning, mandates that training, validation, and testing data sets must meet some quality criteria, and they have to follow some specific data governance and management practices, like the examination in view of possible biases and the identification of any possible shortcomings or data gaps. Even though in reality, the feasibility of this is up for discussion, I think this could make an important contribution nonetheless. In addition, there is this derogation to the GDPR's restriction on using sensitive categories of personal data for the purpose of bias monitoring, detection, and correction, which is quite a welcome exception given the difficulties of tracking, basically, automated discrimination. But that is limited to high-risk systems, and that doesn't go beyond them. And then there's this idea of human oversight, which mentions that overseers should be able to interpret a system's output in light of their knowledge of the system's limitations. And they should also be aware of automation biases. So it looks good on paper in view of literature on, for example, implicit bias and disparate interactions, which is basically the differential interpretation of outputs for different social groups. But the problem is that that provision looks a bit like wishful thinking in light of the fact that overseers will be chosen by operators and not subjected to any specific training or audit requirements. But nonetheless, there's a third point where the AI Act can make a positive contribution, and it's this idea of a public supervisory approach. So I said at the beginning that enforcement of non-discrimination law might be a problem because mostly the system is individual and ex post redress. So now with the AI Act, what we would have is a form of post-market monitoring led by market surveillance authorities, which is basically a welcome form of public supervision, which perhaps responds to some concerns that can be found in other articles of the proposal, like Article 7, which mentions the idea of a dependence of subjects of AI decisions and the existence of power asymmetries vis-a-vis users. So that can really respond to that, but there are some limitations as well. So even though for now, for the positive aspect of this, even though this public supervisory approach is centered on market issues, there are opportunities for third parties with a legitimate interest, like equality bodies, for example, to request access to information. So that could lighten some of the burden of evidence that weighs on individual applicants. But equality bodies differ in their competences at national level, so this will take a very different meaning in different EU member states, because there are differences in standing, there are differences in whether equality bodies are able to decide a claim or not, for example. The big weakness of this is that there's no individual complaint mechanism for individual victims. And in addition to that, organizations with a legitimate interest, so I mentioned equality bodies, but we can also think about national human rights institutions, for example, they can lodge a complaint with the Market Surveillance Authority, but it's far from clear according to what standards and what discrimination expertise this will be investigated. So despite these positive contributions, I think the proposal also really displays a series of major weaknesses. And for the sake of time, I'll just focus in the remainder of the talk on three major epistemic discrepancies and procedural weaknesses, which are going to be the last part of my talk. So the first, and I just want to say that this is going to echo some of the critiques that have been made by the CNIL and by the Défenseur des Droits this morning as well. So the first epistemic discrepancy, so to say, that I want to mention is that the proposal is a sort of regulatory Frankenstein that combines the language and the legal approach of product liability on the one hand, and on the other, the language of fundamental rights. So we have this idea of risk, and on the one hand, we have the idea of safety and health, and on the other, the notion of fundamental rights. And all of these are grouped basically under the notion of harm. And it's an uneasy blending because it's not quite evident how that can work out. Basically, the essential requirements in Title III, they create a regime of risk and conformity assessments, but the threshold of these assessments is quite unclear and is also quite problematically almost entirely in the hands of the providers and users. And this is really alien to the very philosophy and rationale that underpins fundamental rights law. Because although fundamental rights law is not completely unfamiliar with the idea of balancing, because it does rely on balancing as well, although it's not unfamiliar with that idea, this is of a very different nature. So some fundamental rights are quasi-absolute, and all of them are fundamental or essential, as the court has indicated many times. So the qualifications of fundamental rights, like non-discrimination under the Charter, can only take place in the conditions which are set by Article 52.1 of the Charter, which I mentioned earlier on. And that article foresees an open-ended anti-discrimination test, whereby limitations may be made only if they are necessary and genuinely meet objectives of general interest that are recognized by the Union or the need to protect the rights and freedoms of others. And this entire balancing exercise is subjected to the principle of proportionality. So here we have quite a strict judicial review going on, which cannot be reduced to risk assessment balancing equivalent interests, basically. There is a more fundamental aspect to that. And, it opens also further questions such as who decides on whether a residual risk is acceptable? So this is the language we find in the proposal. Or who decides whether these requirements are met sufficiently as demanded by the AI Acts? And what are the thresholds? There is unclarity in this regard. So the idea of non-discrimination by design there really becomes truncated, or at least I think subjected to a very specific idea of what the right to non-discrimination is, and namely the interpretation of providers and users, and maybe that of market authorities, market surveillance authorities. But there is also a second epistemic discrepancy, and it's related to the standardization of equality and non-discrimination. So there, the Draft AI Act foresees that the European Commission will delegate the creation of harmonized standards to standard-setting organizations, and these are private bodies. So following these standards, what would happen is that basically any provider that has followed these standards would be enjoying a presumption of conformity. So meaning that they would be able to circulate, their products would be able to circulate freely in the entire EU internal market. The problem now is that we're going down an uncertain path, and namely that of standardizing equality rights, which I think first are very difficult to translate or to reduce to quantitative metrics. So there has been a lot of work going on in that regard, and standard setting bodies are aware of this. But the second thing is that the meaning of equality is highly contextual. And I think it's worth remembering that philosophers since at least Aristotle and courts all over Europe have been pondering about the meaning of equality and about adequate benchmarks for non-discrimination law for a very long time. So I personally doubt that it's a good idea to entrust the decision, the very normative decision, as regards the underpinnings of non-discrimination law to standardization bodies, which I don't think have the expertise quite to settle this question, and which should probably not normatively settle this question. And another huge issue, of course, which colleagues have already pointed out in papers, which I'm going to mention in a minute, is the lack of democratic control over standard setting processes. So civil society organizations are barely involved, and there is almost no public control over these standards, and most probably no judicial review either. So we are going down a path that could become very problematic in the future. Now, I'll finish this third point by mentioning a third epistemic discrepancy, which is the idea of market uniformity, which you can really see in that idea of the Commission of avoiding fragmentation, and the approach which has been the dominant approach in fundamental rights and in particular in non-discrimination law, which is that of setting minimum requirements. So the next question is, when these harmonized standards have been created, what happens? Which non-discrimination law requirements do they take as a basis? Is it the long list of prohibited criteria that Gaëtan and Félicien have mentioned in relation to France? Or is it the very limited list of 6 protected criteria that is set at EU level? So this is quite unclear, and I don't think the minimum harmonization approach of fundamental rights law quite fits with the market uniformity approach that the Draft AI Act adopts. And now the next question is, what will member states be able to say? Will they be able to say, well, we can't let that product through because we protect our citizens from discrimination based on health or socioeconomic status, and this AI system creates discrimination on this basis? And if they say so, the next question is, well, will we end up with the Laval and Viking crisis situation again? So I think the AI Act poses a number of really fundamental questions that are not only social justice questions, but also fundamental questions pertaining to the legal order of the European Union. And that was a partial account, but we can conclude with some ideas. So the first is that although the AI Draft Act makes some positive contributions to the gaps of EU non-discrimination law, it also poses many questions and also makes some kinds of dangerous moves that call for, I think, careful rethinking of some of the provisions that I've mentioned. The second thing is that some of the limitations of the Draft Act pertain also to the rigidity of the list of high-risk systems. And I'm thinking there in particular of the notion of systemic discrimination. So this is a notion that has enjoyed some attention for some time, but has not yet become recognized at doctrinal level, at least not in the EU. And the idea there is that some limited risk systems, like those pertaining to, the distribution of goods and services, which can be considered non-essential as opposed to the essential services mentioned in the list of high-risk systems, for example, pertaining to culture, pertaining to basically cultural goods, they can really shape our implicit values and our implicit biases, and also contribute to reinforcing or dislodging some social hierarchies. And in that regard, I think they are liable to create systemic discrimination. But unfortunately, seeing how the AI Act is construed at the moment, I don't think these systems would necessarily be captured by the provisions that the Act makes. And in addition to, and this is my last point, in addition to falling short of appropriately addressing the challenges of algorithmic discrimination and its legal redress, I think the Act is also ineffective in two regards. The first one is addressing fragmentation, because potentially it creates sharp socio-legal conflicts at the intersection of market and fundamental rights interests. And the second issue is that it probably also increases legal uncertainty for citizens and the industry, at least in some regards. And I want to give some credit to some of the literature that speaks to the points that I have made today, which you can see on the screen and which you'll be able to have a look later on in the slides. And so now all what I would like to do is to thank you for your attention and to invite you to reach out should you be willing to do so. Thank you.